I am going to be precise about something right at the start. I am not going to tell you what was in the documents, not specifically. Not because I am protecting anyone, I am done protecting anyone, but because the moment I start naming specific things, this becomes about those specific things, and people argue about the details, and the larger picture gets lost. And the larger picture is what I actually want you to understand. What I am going to tell you is how it all works. The structure, the legal architecture that makes an organization like this not just survivable, but practically untouchable. How they use the law, not to stay legal, but to stay hidden inside legality. Those are not the same thing, and understanding the difference is the whole point. I was their lawyer for 8 years. I drafted agreements. I structured entities. I filed documents in jurisdictions chosen specifically because of what those jurisdictions do not require anyone to disclose. I sat in rooms with people whose names I will not say, and I made sure that what they were doing was, technically, not illegal. I was very good at that. 3 years ago, I stopped. And here is what I want to tell you about all of it. I went to law school wanting to do something that mattered. I know that sounds naive for a story that ends here, but it is true. I had a specific idea of what law could be, a mechanism for making power accountable. I believed that pretty sincerely for the first several years of my career. I went into corporate law because the money was real, and I had student loans that were also real, and I told myself it was temporary. I would do this for a few years and then move into something more meaningful. That is what a lot of people tell themselves. The few years have a way of becoming many years if the money keeps being what it is, and the work keeps being what it is, and the lifestyle that builds around those things keeps being what it is. By my late 30s, I was a senior associate at a firm that handled, among other things, a specific category of client that I will describe as private entities with complex structural requirements and a strong preference for discretion. That is lawyer language for organizations that need to do things without anyone knowing they are doing them and need it done correctly enough that it holds up. I was good at the structural work. Very good. And being very good at something specific, in law, means that specific work finds you. You do not always go looking for it. It starts arriving. The first contact from what I eventually understood to be this organization came through a referral from a senior partner. A new client. Private investment collective, he said. Significant assets across multiple jurisdictions. Complex compliance requirements. Needs someone who understands how to structure things across legal environments that do not always speak to each other. That was my description, more or less. I was that person. I met the initial contact at a private dining room in a hotel I will not name. The man across from me was probably 65. Precise. The kind of precise that comes from a lifetime of choosing every word on purpose. He explained what the entity needed in terms that were technically complete and personally revealing of almost nothing. I said I could handle it. I could. And I did. For 8 years. Let me explain how this kind of organization protects itself legally, because I think most people imagine it wrong. The common image is that there are secret documents somewhere with everything written down. Memberships, plans, transactions, all of it clearly labeled and hidden in one place. That is not how it works. If it worked that way, it would be vulnerable. One discovery order, one whistleblower with access to that one place, and it all surfaces. The actual structure is designed precisely to prevent that. What I worked with, and what I built pieces of, was a distributed architecture of entities across multiple jurisdictions. Not one organization, dozens of organizations. Some of them publicly registered with clean profiles and legitimate-looking purposes. Some registered in jurisdictions where beneficial ownership does not have to be disclosed, meaning you can own a company and nobody outside the company has to know you own it. Some existing as trusts rather than corporations, which carry different disclosure requirements in most places. Some existing only as relationships between other entities, with no separate registration at all. The money moves between these entities in ways that are individually explainable. Any single transaction, looked at alone, makes sense. A foundation makes a grant to an educational organization. A holding company pays a consulting fee to a management company. A trust distributes assets to beneficiaries as specified in its founding documents. Each transaction has paperwork. Each piece of paperwork references legitimate purposes. The aggregate, what the money is actually doing over time and at scale, is not visible from any single document or any single jurisdiction. The agreements I drafted were written in standard legal language. They were not coded or obscure. A competent attorney reading any one of them would find nothing obviously wrong. The structure they created together was another matter, but you would have to see all of them, understand how they connected, and have context that was not written into any single document to understand what the structure actually did. That is the design. Not to hide individual documents, to ensure that no one person ever has enough of the picture to see the whole thing, including, deliberately, the lawyers. I understood a significant portion of it, more than I was supposed to. That is a consequence of being very good at structural work. You start seeing the shape of things you were only shown a corner of. Attorney-client privilege is a real and important legal protection. I want to be clear that I believe in it. The principle that a client can speak honestly to their lawyer without that communication being used against them is foundational to how legal representation works. It is also one of the most powerful shields an organization like this can put between itself and scrutiny. And the people running this organization understood that better than most. Everything I knew in the context of a privileged relationship, which meant that if anyone ever asked me what I knew, a regulator, an investigator, a journalist, my answer was the same. I cannot discuss client matters. That is not obstruction. That is not deception. That is the law. And it is true. And it protected them for 8 years while I was inside it, and would have continued to protect them indefinitely if I had stayed. The confidentiality agreements I signed went further than the standard privilege. Layered on top of it were contractual obligations with significant financial penalties, jurisdiction clauses that placed any dispute in locations chosen for how long and expensive litigation there tends to be. And in one case, a clause I had never seen before, and have not seen since, that I am going to describe only as unusually creative in how it defined the consequences of disclosure. I am a lawyer. I understand contracts. I understand what I signed. I signed it anyway because at the time I understood the risk intellectually, but did not feel it in any immediate way. That is how it works. The consequences of disclosure feel abstract right up until they do not. 3 years out, they feel considerably less abstract. I am telling you this from a position that I spent a lot of time preparing. I am not being reckless. But I am also done with the professional silence that the structure was designed to enforce indefinitely. I am not going to describe them specifically. What I will tell you is what kind of people they were, in terms of how they operated and how they thought, because I think that matters more than any individual detail. They were not dramatic. That is the first thing. The image most people have of the people at the top of something like this is dramatic. Robes, rituals, theatrics. The people I sat across from in conference rooms and private dining rooms were indistinguishable, on the surface, from any other group of wealthy, powerful, experienced people conducting serious business. They were deliberate. They were patient. They had a relationship with time that most people do not have. They were not thinking in quarters or years. They were thinking in decades, and that changes how you make decisions about everything. They were also, and this is the part I found most unsettling over time, genuinely convinced of their own legitimacy. Not performing legitimacy, actually feeling it. The framing that I encountered consistently was that what they were doing was necessary, that the world required a certain kind of management, that democratic institutions were too slow, too visible, and too subject to short-term pressures to provide. That they were the people willing to do what needed to be done in the way it needed to be done because nobody else had the position or the patience or the perspective to do it. I have spent a lot of time thinking about whether they believed that or whether it was a story they told. My honest conclusion is that most of them believed it. People are very good at constructing moral frameworks that justify what they were going to do anyway. The belief was real. What it justified was another matter. There were people in those rooms I respected, genuinely. People whose intelligence was real and whose concern for certain outcomes seemed real. There were also people in those rooms who I would describe, as plainly as I can, as dangerous. Not visibly, not in any way you would pick up on in an initial meeting. Just, over time, when you understood what they were willing to do and what they were willing to use other people for. Dangerous. The mix of those two types in the same organization, pursuing the same goals, using the same structure, that is something I think about a lot. I said at the start that I would not tell you specifically what was in the documents. I am going to keep that. But I can tell you what categories of things they contained, because the categories themselves are telling. There were documents that established the real ownership of assets that were publicly attributed to other owners. Not falsely attributed in a way that was illegal on its face. Attributed through layers of legitimate entities such that the true beneficial owner was technically disclosed somewhere in the chain, but practically unidentifiable without knowing where to look, and having legal standing to compel disclosure, which nobody did. There were agreements between individuals in positions of significant public trust and entities connected to the organization. Again, structured carefully. Nothing that read as a bribe, everything framed as consulting, as advisory services, as investment returns on legitimate positions. The framing was real. The underlying relationship was something else. There were documents related to events, things that happened, things that were attributed publicly to one cause and were connected, in these documents, to a different cause or a different set of actors. I am being deliberately vague because the specifics are where this gets complicated and where I made the decision not to go. What I will say is that reading those documents changed how I understood several things I thought I had already understood. And there was one document, one specific document, that I read about 14 months before I left. I was not supposed to have access to it. It came to me by accident, through a misfiled attachment in a document production I was managing. I read it before I understood what it was. By the time I understood what it was, I had already read it. I am not going to describe what it contained. I want to be honest about why. Part of the reason is the legal exposure I described earlier, but part of the reason is simpler. I have not fully decided what to do with what I know about that specific document, and saying something here that cannot be unsaid before I have made that decision would be the wrong move. What I will tell you is that it changed things. Not because it revealed something I had no category for, by that point I had categories for most things, but because it made the scale of what I had been facilitating, over 8 years, concrete in a way that the structural work had let me avoid confronting directly. You can draft agreements for a long time without fully confronting what the agreements are for. The document removed that option. I did not leave immediately. I want to be honest about that because I think the honest version is more useful than a version where I immediately did the right thing. For about 6 months after reading that document, I continued working. I told myself I needed time. I told myself I was gathering information. I told myself I was figuring out the right approach. Some of that was true. A lot of it was me not being ready to face what walking away was actually going to cost. The cost was not primarily financial, though that was real. I had built a practice, a reputation, a professional network over 8 years that was substantially connected to this client and the related work. Walking away from the client meant walking away from a significant portion of what I had built. Not all of it, but enough that the professional impact would be real and lasting. More than the financial cost, the cost I was most reluctant to face was simpler. I had been part of this for 8 years. I had made it work. I had made it more efficient and more protected than it was when I arrived. The document I read did not reveal something the organization had done that I had not been helping to enable. It just made the enabling undeniable, in a way that my professional framing of the work had previously allowed me to avoid. That is a specific kind of reckoning. Not discovering that you have been working for bad people, discovering that you already knew, at some level, and had chosen the framing that let you not fully know it. Lawyers are very good at framing. It is the skill. I had used it on my own understanding of my own work for 8 years. and the document cut through the framing in a way I could not reframe my way around. The 6 months after were me sitting with that. The 8 months after that were me building the exit, carefully, methodically, the way you do something when you understand that doing it wrong has consequences. When I finally withdrew from the representation, I did it through channels that were professionally clean. Health reasons, personal circumstances, practice restructuring. All technically true in various ways. The withdrawal was accepted. They had other lawyers. I was not irreplaceable, and I believe they were, by that point, aware that I had become someone to manage rather than an asset to retain. The actual exit was quiet. No confrontation, no final conversation where anyone said anything direct. That was probably by design on both sides. I have a smaller practice now, a real one. Smaller clients, more straightforward work. The kind of law I told myself in law school I would end up doing. It pays considerably less. I am okay with that in a way I would not have predicted 10 years ago. The professional consequences were real but survivable. Some relationships ended, some referral sources dried up. A few clients I had outside the organization quietly moved their work elsewhere around the time I withdrew, which told me something about how interconnected things were that I had not fully mapped while I was inside. There have been no direct consequences from the organization itself. No contact, no legal action, no visit in a parking garage. I am not going to claim that means there will not be. I prepared for that possibility before I started doing anything like this. What I will say is that 3 years of quiet suggests that managing me passively, letting me leave without drama, counting on the legal obligations I signed to keep me quiet, was the calculation they made. I think they believed the agreements I signed were sufficient. They were sufficient for 3 years. I am sitting here now because I have decided they are not sufficient indefinitely. I want to be clear about what I mean by that. I am not releasing documents. I am not naming names. I am not making specific accusations that I am prepared to substantiate in a legal proceeding tomorrow. What I am doing is describing how these structures work, from the inside, in enough detail that people who want to understand how organizations like this stay hidden can understand it better. That feels like the version of this I can do right now. The other version, the more complete version, is something I am still working toward and still deciding about. I do not know what that looks like yet. I know it exists. There is a version of this story that people want to hear that goes, secret, powerful organization, hidden documents, everything exposed, justice served. Clean, satisfying. I understand why that version is appealing. The reality is messier, and I think it is important to say so. The legal structure these organizations use is not exotic. It is built from tools that are used every day by legitimate organizations for legitimate purposes. Shell companies, trusts, complex ownership chains, jurisdictional arbitrage. These are standard instruments of sophisticated legal and financial practice. The tools are not evil. The tools are just tools. What matters is what they are being used for and by whom. The reason this is important is that it means there is no single legal mechanism that fixes it. You cannot ban shell companies and solve the problem because shell companies have thousands of legitimate uses. You cannot reform attorney-client privilege and solve the problem because attorney-client privilege is foundational to the legal system. You cannot require disclosure in one jurisdiction and solve the problem because there are always other jurisdictions. The architecture is designed to survive legal reform. Each individual piece of it is legitimate enough that reforming it away would require reforms that most people would not accept, because the reforms would impact legitimate uses more visibly than they would impact this use. That is not an accident. That is a feature. So when people ask me what the solution is, my honest answer is that I do not have a clean one. What I have is the belief that the more people understand how these structures work, not the emotional version, the actual mechanical version, the harder it becomes to operate them without being seen. Opacity is the operating condition. Reducing opacity is the only thing that actually matters. Understanding how the hiding works is the beginning of seeing through it. Why are you doing this? I have been asked that by the handful of people who knew anything about my thinking over the past 3 years. I have asked it myself, honestly, more than a few times. The practical answer is that the legal obligations I signed, while real, do not prevent me from describing general structural mechanisms that I observed in a professional context. I am not disclosing client confidences in the legal sense of that phrase. I am describing how a category of legal architecture works, from the perspective of someone who has built pieces of it. That is legally distinguishable. My lawyers agree. It is not a comfortable distinction, but it is a real one. The actual answer is simpler. I spent 8 years making something more protected than it was when I found it. I was good at it, and I was paid well for it. And I told myself the professional framing that let me do it without confronting fully what I was doing. Then I read a document, and the framing stopped working. I cannot undraft the agreements I drafted. I cannot unstructure the structures I built. 8 years of work sits in document boxes in rooms I will not have access to again. And whatever those documents protect, they will go on protecting it. What I can do is describe the shape of how it works. Clearly enough that people who are paying attention can use it. Clearly enough that the next lawyer who gets approached by something that looks like what approached me has a slightly better chance of understanding what they are actually being asked to join. That is what this is. That is why I am here. If you work in law, in finance, in accounting, in any field where your professional skill is the thing being purchased, this is specifically for you. The organizations I am describing do not build their own legal structures. They hire people like me to build them. And they hire people like me by starting with something that looks entirely normal. A client with complex needs and a preference for discretion. Every client has complex needs. Lots of clients prefer discretion. There is nothing in that description that distinguishes a legitimate client from what I ended up representing. The signals, when they came, were subtle. Requests to use specific jurisdictions I would not normally reach for. Preferences for structural complexity that exceeded what the legitimate purpose would have required. Resistance to certain types of disclosure that were voluntary but conventional. A level of compartmentalization in how information was shared with me. I was only ever shown the piece directly relevant to what I was being asked to do, never the larger context. None of those things, individually, would have made a competent lawyer refuse the engagement. All of them together, if I had been paying a different kind of attention, would have told me something worth knowing earlier than I knew it. Pay that kind of attention. The professional obligation you have to your client is real. The professional obligation you have to not become a mechanism for something you would not choose to enable if you understood it fully. That is also real, even when it is harder to enforce. And for everyone else, the legal system is not neutral. It is a tool. Like any tool, it can be used well or badly, and the outcome depends entirely on who is using it and toward what end. Understanding how the tool works, how it can be used to hide things in plain sight, how legitimate mechanisms can be assembled into illegitimate structures. That understanding belongs to everyone, not just to the lawyers who get paid to know it. I spent 8 years knowing it on behalf of people who counted on me not sharing it. I am sharing it now. Make of it what you can. I drafted a lot of documents in 8 years. Agreements that moved money, protected ownership, established relationships, created structures. All of it technically legal. All of it professionally executed. The document I read by accident, 14 months before I left. I have read a lot of documents. I have read documents in 6 languages across maybe 20 jurisdictions. I have read things that were designed to be misunderstood and things that were designed not to be found. That one was different, not because of what it revealed about the organization, because of what it revealed about what I had been building toward, without knowing I was building toward it, for 8 years. I finished reading it in a parking garage, because that is where I happened to be when the attachment came through, and I opened it without checking what it was first. I stood there for a while, then I drove home. I did not tell anyone. I went through my normal evening, had dinner, watched something I do not remember, went to sleep. And in the morning, the framing I had used to understand my own work for 8 years was gone. Not gradually, just gone. like something that had been holding a shape collapsing when you remove the thing that was holding it. You cannot go back from that. You can delay. You can keep working for another 14 months while you decide what to do. But you cannot go back to before you understood what you understood. That is where I am. 3 years past that morning. Still deciding in some ways, moving forward in others. Whatever those documents ultimately show the world, when they show it, I will not have been the one to make them stop being hidden. But I will have been the one who, at minimum, told people that they exist, that they are real, and that the law is not always what is standing between those documents and the people they concern. Sometimes the law is what is standing in the way of that. Know that. It matters.